Dear ladies and gentlemen, Joy Stephen from the Polensis Studios. This is a case law for the Student Herald. Case laws are not meant for people interested to apply for permanent residence to Canada, but may be used by those who feel the system may not be fair or to gain an understanding of the recourse available in Canada in case there is a negative decision. Content for this video is sourced from information distributed by Thomson Reuters. Judgment for this case is attached in my blog reportersreport.com as a PDF document. Now, this is an immigration video. This case is about refugee status, requirements, well-founded fear of persecution, presumption of state protection. Now, the case is about a refugee claimant, 21 years old, Colombian citizen, who alleged fear of persecution by Revolutionary Armed Forces of Colombia, or FARC. Claimant alleged that his mother and father has been harassed by FARC since 1997, and his father had been asked to work for FARC. That family had received threatening phone calls, and FARC had attempted to extort money from the family. Claimant alleged that in 2011, FARC started referring to him in their phone calls, claiming that they knew where to find him and wanted to recruit him. Claimant's family made denunciation to Attorney General, who sent letter to local police requesting protection for claimant's family. Protection had been provided for 1 week. Parents sent claimant to Canada 4 days after denunciation in December 2011 because they were concerned about risk of claimant being kidnapped or recruited by FARC. Board gave little weight to the telephone testimony of claimant's family. Claimant's father, because he had vested interest in outcome. Board found claimant had not rebutted presumption of state protection and denied the claim. Claimant applied for judicial review. Application was granted, decision squashed, and the matter returned for reconsideration by a different board member. Only father had direct evidence of what FARC was threatening to do to the claimant. It appeared that board discounted direct evidence given under oath so that it did not have to consider whether father could clarify problems it had identified with claimant's own evidence. This was grossly unfair and entirely against claimant where threats against claimant were appropriately assessed. Board could not conduct reasonable state protection analysis and therefore discounted evidence that from father was also relevant to state protection. There was strong evidence before board that state could not protect someone in claimant's position, but board never engaged with this evidence in any meaningful way and focused upon initiatives which did not support findings of adequate state protection for someone in claimant's position. However, board never states whether its state protection findings were made on assumption that FARC's threat against claimant were true or on assumptions that threats were not true. Therefore, it was not clear extent to which board's unreasonable negative credibility findings impacted its state protection analysis. For these reasons, decision was unreasonable and the review was granted. Varon versus Canada, another interesting case of the federal court, March 20th, 2015. Thank you.